morning. My name is Eric. I live in Hamilton, Ontario. Want to talk about my experiences self-representing in the family court. So I have an active current case. I'm going to try and not get into too many details or anything. I don't want to talk bad about anyone. I just want to talk about the experiences self-representing. Hopefully this can help other people in my situation. So I'm not I can't give legal advice. I can give friendly advice. This is only gonna help people who are in my situation. I think they call it a high conflict case. Allegations of parental alienation, allegations of domestic abuse, withholding of children, threats to remove from the jurisdiction, stuff like that. So, even if that stuff's not all credible, it's they they take it at its face value at the start. So it makes it a high conflict case, and there's already a legal framework for how the court wants to deal with high conflict cases where one party is self-represented, especially when there's allegations of domestic abuse. It's evidently it's so common that the court has a procedure for it in writing. Has to do with, it pops up in places like, for example, the requirement to confer is somewhat alleviated from the victim in cases of domestic abuse allegations. They they don't have to talk to you throughout the case, especially if you're self-represented. So I don't want to talk forever in this video. I don't want to ramble. I'm already 2 minutes in. We'll call that the intro. So let's talk first about the level of court that we're dealing with. As I said, I'm in Hamilton. I feel that Hamilton has a bit of maybe a reputation in the family court system for good and for bad. And I'll move right into saying that self-represented people are seen as a bit of a plague in the system. On one hand, they're writing rules to accommodate self-represented people and principles, and then on the other hand, they complain about it. They flat out complain about it. They complain about the amount of extra work that we need, the amount of extra help that we need, the way we bumble and fumble through the case, have unrealistic expectations, etc., etc. So you got to read this stuff. You got to search this out and read this. You have to, knowledge is power. You have to come from a position of strength. You can't skip over this. You need to get their perspectives first. You need to get the perspectives of the court and the judges and the other lawyers. You have to listen to where they're coming from. They're going to try and help, but they also don't like you, and you're a nuisance. And if your matter needs to really be put before a judge and you don't even have a lawyer, then they know what kind of disaster is already in. And so, again, this is only for people in my situation. Like, your matter needs to be adjudicated, then you're all the way over here already. Because if your matter doesn't have a need for adjudication, you shouldn't be asking for it. And that's one thing they want you to understand. If you can pursue mediation, do it. The court wants you to go through mediation before you commence adversarial proceedings. Separation agreement can be a very expensive thing. So if you're poor and you don't have assets and you're fixing for a high conflict case, you're in big trouble because you probably can't afford to have a proper separation agreement, because you each need counsel. And let me tell you something about lawyers. You can instruct them to write a separation agreement, and they might say, well, I think you can get more. Maybe we should open a case, and if either one of you listens to them, now you have a case on your hands, right? And there's a presumption in a case that eventually at the end there's a decision. So this is moving forward here. The case is either decided by settlement, or it's decided by trial, or the court dumps it. Or, again, I'm not a lawyer, I'm just speaking on my experiences. Okay. So you're in my situation, you're a dad, you need to self-represent Ontario Family Court. You probably want to do what I did. I'm not saying this isn't advice. I'm not suggesting you do what I did. The opposite. But you're probably tempted to just start trying to get decisions and have adversarial proceedings right away, maybe. I'll just say it, like urgent motions, right? You may be curious about it. I opened my case with an urgent motion. Was it smart? I don't know. Did it work for me? A little bit. It did, but it's not over. My case is set for a second settlement conference today, which I feel is maybe unusual. Like, I don't think there's usually 2 settlement conferences. I'll try to get more into that in a bit. So, should you start off with an urgent motion? Well, the grounds for urgency are in the family law rules, Rule 14, 4.2 or whatever. There's some grounds for urgency, like hardship, but that's a high threshold of hardship. Here's the thing, right? If you're my chief argument at the time was, I haven't seen my kids in 8 months. She just took them and wouldn't let me see them. So I considered that to be hardship, but the court doesn't consider that to be hardship. The only actual threshold that was that I think now in retrospect caused my motion to be heard at all was the somewhat credible evidence about threats to remove them from the jurisdiction. I got child passport applications in the mail last September, which were kind of like just provocative. I hadn't seen my kids since February. I'm getting these passport applications. She wants me to fill it out and send it back, and meanwhile I have a no contact order from the criminal court. I'm on probation or whatever for a domestic from 5 years ago. And we're going to talk about that too. So I'm not seeing my kids. I get these passports applications. I haven't brought a case yet because I'm on probation, and because basically all I'm doing at this point is crying about it. So this is a year ago. So anyway, come October 2023, I got fired off this urgent motion. The judge heard the motion, and I'm over here thinking, oh, okay, she's gonna send the kids to my place for a little bit because she's not sharing the mother's not sharing them. The judge is gonna understand. No. So I think it's Rule 35. But I don't know. I don't have the rules in front of me. But basically, a judge can't order parenting time without a parenting affidavit. So your parenting affidavit is part of your pleadings, and your pleadings are the way the court wants you to start a case. So at my urgent motion, the judge makes an order on me to start a case. Okay. But I didn't get an order for parenting time. I didn't get to see my kids for another 3 months, but She was ordered not, neither party without prejudice was permitted to take them out of the jurisdiction. So, in that sense, the urgency was addressed by the court. And that's the best you're going to hope for. Is they're going to identify if there truly is an urgent situation, and if there is, they're going to crush it. And that's it. And then the rest has to be handled through normal means. And what I mean by this is they want you to settle. But they understand some issues cannot be settled. They just hold things in both hands simultaneously. It's, it's like Schrodinger's law. They want you to settle. So, me, I'm the applicant. And I brought a claim for parenting time and decision making. I decided just to drop the decision making claim and settle it. She brought a counterclaim for spousal support, restraining order, child support, sole decision making, whatever, the full nine. I didn't understand right away that I have to just settle all their claims. I thought, oh great, I have to fight all of this. So anyway, your pleadings. This here, as a self-represented person, what do I have here? These are the pleadings bundles here. There's lots of information online about the old paper filing system and how they want things paper filed, and there's a little bit less about using the online portal, but just accept that you're going to be using the online portal. It's not hard. I thought it was going to be paper filing. Anyhow, you're in for a lot of paperwork. You got to keep stuff organized. You need to learn how to do the forms. When you're doing your pleadings, I do not recommend you use Clio, community something online, that fill your forms for you. Don't do that. You need to read all the rule book first. Family law rules. You need to read them all a few times. It takes an hour to read the family law rules. So spend a half hour a day for a week. Just keep reading them, excuse me, until you can recite them. Don't fall into the trap of thinking those are the only rules you need to follow, because they're not. We have the rules of civil procedure, which you're probably barely going to look at. And then there's the Evidence Act, which you should definitely look at. So the forms are on the internet. Here's some really good advice to a self-represented person right here. Download the forms to your computer straight from the source. Use the doc file format. When sometimes they give you both types, use the doc format. Don't do it on your computer software. Do it online. Get a subscription to like PDF filler, some form filler software that has powers of PDF to work with them, and work over top of the DOC file format too. All you can do is all you can do. You need to make your stuff at least look polished. Like my pleadings were a disaster. It's humiliating. I use this Clio thing and it's brutal. So I've been playing the game of catch up ever since then to clean up my forms, make my documents look better. So like I said, I'm scheduled for a second settlement conference today. So I'm going to pull out my paperwork for that. And I'll just, here's my forms. They look good. They look good. I'm not going to pull them any closer, but they look good. They're polished. I've put a lot of work into properly filling these forms out. And I look at the opposing lawyers' forms. They come from divorcemate.com. So there's a footnote, divorcemate.com, on every sheet of paper in the record. They're blotchy. I can see blotch across all of these pages. And I don't know. If I were a judge, I might think, what the hell? It might make me laugh a little bit. But you can at least empower yourself to do a good job. And try and look like you care about the process. It hasn't worked out for me yet, I don't think, but I wouldn't not do it. Consent orders. Let's talk about consent orders. Let's see, I'm 15 minutes in. I wanted to stop at 15 minutes, but I'm getting nowhere here, so we're going for 30. If you're in my situation, if you made it 15 minutes through, you're gonna make it another 15 minutes. Because you want to know everything. So the case conference. If you haven't had a case conference yet, you need to have one. You can't bring motions before a case conference. That's Rule 14.4. The case conference has to be about the substantive issues that you want to have a motion about. There's lots of tricks and traps in this that they don't tell you. If you're self-represented, they don't tell you on purpose. The first thing is there's not really a difference between a consent order and what you might think of as kind of a adversarial order. I mean, a consent order happens at a conference, or you know, you bring up it's called a 14B motion. If you have consent and you want to order on consent, you don't need to have a hearing. You can settle it in chambers. You can settle it at a conference. If you get an order at a case conference, you have to follow it. I got an order for parenting time. So here's the thing, okay, I got a little bit of legal advice from a lawyer in Hamilton. She said, okay, go to your case conference, you'll get an order for supervised visits. It's not a maybe, she goes, it's going to happen. So she's very confident the other lawyer is gonna let me see my kids. Again, I'll remind you, we're in roughly November of 2023 and I hadn't seen my kids for like 9 months now. I'm devastated, right? Anyway, now this is a year ago. So I've handled these emotions now, so I'm not going to get emotional about it. So I go to this case conference. Here I am emotional, but anyway, what I didn't know was that it's kind of one or the other. You're going to get your parenting order at the case conference, or you're going to get it at a motion right after the case conference because you didn't like the deal. It's not both. You don't take the deal at the case conference and then bring a motion for asking for a better deal. The judge will not like that. You need to trigger the change in circumstances threshold to change an order. That applies to interlocutory temporary orders. The word is interlocutory. Interlocutory orders are appealable to the divisional court, not the Court of Appeal, and you need the court's permission to appeal to the divisional court a temporary order. That's just an aside. So don't think you're going to be appealing anything because you have to get leave from the court, and they're not going to give it to you if you're self-represented. So if you're going to consent to an order, you better like it. I got an order for 6 supervised visits. I had to pay for them. Anyway, it took a month to get the first visit down. Everybody hated it. It wasn't no fun. And I thought, oh, okay, I'm just going to bring a motion now. Because here's the thing, the judge at the case conference says something to that effect. But what she didn't outright tell me was, you got to pick one. You either take the consent order or you have a hearing. It's I didn't understand that. What I thought was, oh, once you had the case conference, doors blown wide open and you can bring all the motions you want. And I thought, oh, okay, this is how this works. It's not how it works. You get a parenting order, you've got your order. That it may be temporary, but you got your order. So as far as the court's concerned, shouldn't be coming back to court at you're not trying to get a better order. You consented to it. So you go to the case conference, you either get your order and you're happy with it, or you say no. And then bring a motion. So what I did, let's move on to the motions phase now, after the case conference. Let's say you consented to your order, your parenting order. Obviously you consented to the child support order. You're not fighting the child support order, you're paying the table amount. Actually, we're going to skip the motions phase for a minute. We're going to talk about financial disclosure. Your job is to do a good job on this. Remember what I said about form filler software? The Form 13 is really intimidating. You got to get all your affairs in order. If you're going to open a case as the applicant, like I did, you should get all of your affairs in order, because nobody is going to look favorably on delinquency. So your tax returns need to be up to date. Everything needs to be filed. You need to have your notices of assessment on hand. If you don't have credentials to the CRA website, you need to get them. Like simple stuff, you got to get that all in order. It's intimidating for some people, but you need to know. You need your pay stubs, or if you're self-employed, God forbid, you need. Like, I own a corporation, so I opened it. It was in my first year that I opened my court case, so I didn't have any. Self-employed people, your company's money is vulnerable, so you need a good reason. You need to account for it correctly. How much you're taking, you need to be honest with yourself and honest with the other party, and especially honest with the court. You need to be honest with everyone about everything. How much money you're taking, how much money you're making. Pay the table amount. What I found is that if I just consent right away to the table amount, then I get to name my price. And because the other side doesn't want to have to bring a motion, they're consenting too. So if you consent to the table amount, there's a good chance the other side will consent to the table amount and issue a child support. You'll get a temporary order at the case conference. But that Form 13 is not easy to fill out. I suggest doing some spreadsheets on the back end for having your own accounting information figured out. And don't lie. Just do it right, make it look good, make everything look polished. Your parenting affidavit, it's the same thing. Here, you don't want to even really talk about the other side. You want to talk about you and your plan for parenting your kids. If you have someone living with you, you got to talk about them, how much money they make, all that stuff. You can't just decide on your own. I don't want to talk about that. Just give them everything they ask for. Half of it, it might not even ever come up unless you don't give it, and then it comes up. Don't ask for summary judgment. Don't be a self-represented person who refuses to get legal advice, comes across Rule 16 in the family law rules, and learns that, oh, a judge can decide my case out of motion next week. Don't think like that. It's not true. If you bring a motion for summary judgment and you're self-represented or whatever, you're wrong, which you probably are, you're in big trouble. You're gonna pay the costs. I got away really cheap. I got a $2,000 cost award. The other side wanted $3,000. It could have, who knows. The thing about this is that there's the rules of civil procedure as well, which have I think it's like Rule 31 in the civil procedure summary judgment. And that's like an umbrella above the family law rules. So just because the family law rules have a little chit chat section about summary judgment, don't think you know anything about this concept. Like, if you're in a high conflict case and if the other party's participating, if you've brought the application, which you should, if you need parenting time, you should be the applicant. Don't let everyone be calling you the respondent the whole time. You start the case. And then you consent to the child support at the case conference. And you go from there. Don't ask for summary judgment, because the consequences of having a motion for summary judgment dismissed are that your case is set for trial. But the other consequences are, of course, you have to pay the cost of the motion because it's going to be a failure. And then I don't know if it's really going to pay off for me or not in the end, because I put my entire story in affidavit form, and I went the whole 12-page limit. So I have an affidavit with all of my evidence and testimony, and then in response, I got their baloney affidavit, but at least it's sworn and signed now, not like their pleadings. You know, so not like you can cross-examine them at trial on things that are in a sworn statement. So if they write some stuff in their pleadings, you can't really cross-examine them on it to the same threshold that you can if they write it in an affidavit. So that's kind of the plus side to me asking for the summary judgment, but it was not smart. The judiciary is all federally appointed, so they're VIPs. Very important people, and they do very important things, and you can't waste their time. If a judge calls you reckless in writing, which is what happened to me because I asked for summary judgment without knowing what I'm doing, thinking I have to try everything. I'm thinking I'm doing the right thing, and then next thing you know, the federal judge calls you reckless in writing for everyone else to see. That's code for sociopath. They speak in code, of course. It's pretty obvious. So you don't want that. Now I'm up against that. But he also says, thankfully, I have no doubt in his sincere interest in his children. This concept here of best interest, we're 27 minutes in, I guess. Best interest of the children, like, it may not be what you think it is. It really boils down to actually how much you support the relationship with the other parent. Let's just stop right there. You know, you have the views and preferences of the child. You have whether one person has been a domestic abuser, whether one person has acted in a coercive, controlling way, all this negative stuff. But generally, the number one thing is actually the courts don't want you around, they just want you parenting. And so if you're going to share the children with the other parent, you're acting in their best interest. So just don't forget that. Like, look it up. It's in writing. There's like 9 criteria best interest of the children. You don't have to be able to recite them, but you should know what's going on. Anyway, material change in circumstances to trigger needs to be triggered in order to ask for a different order. So what I learned from a lawyer is that maybe happens after a few visits. Like, if you're ordered to do your supervised visits, whether it's on consent or not, you got to do them. For me, it was 6. I had to do all 6. She made it really hard for me. Like, I started seeing my kids in February, and I saw them only 3 times before the settlement conference, which was in May. So, yeah, more about the paperwork. Yeah, it shows you my pleadings bundle. These are my motions, affidavits and stuff, asking for, here's my summary judgment motion, which was dismissed in 10 minutes, right? This is like 20 hours of work, and dismissed, and I had to pay $2,000. So don't be a damn fool. These are our settlement stuff. Uh, yeah, I actually signed an agreement to pay spousal support, and then had to ask the court to turn it back around on him because she didn't serve financial disclosure, complete financial disclosure. She lied about her disclosure, left a lot of stuff out, and basically I just told the judge, like, you know, she's impeachable, and you got to set this agreement aside, and actually it kind of worked out. And then at the settlement conference, they took the first offer I made. Um, so I think they probably knew they were licked, but what am I trying to say? You got to settle the other side's claims, because if you're a dad like me and you're asking for parenting time like me, then you have to show, you got to put your money where your mouth is. You got to show you mean business. You can't fight child support. You have to pay it, the table amount. Just pay the table amount. You'd be amazed what happens if you just make it easy for them. Don't really fight decision making, like, unless you actually want to determine where your kids go to school and what their extracurricular activities will be and what their religion is going to be like. If you need a legal right, if these are contentious things you need a legal right for, then you have your reasons. But if it's just some trophy on the shelf because it used to be called custody and it feels bad, forget it. Just forget it. If you want parenting time, you just focus on getting parenting time, because what's going to happen is if the other side doesn't follow the parenting time order, then you come back to court, and now you've triggered a change in circumstances where they can look at decision making, and then they can look at this point where the children will live. You don't. This is what I'm trying to say. You don't need to handle everything at once. If your ex is not sharing the kids, then you're in my situation. If your kids have not been permitted to come to your house in a year and a half, close to 2 years, you're in my situation. Then me, all I need is this order for parenting time that says they can come here. Because in the last year and a half, I've only seen my kids 6 times, and they've been supervised visits, 3 hours apiece in Burlington, and it costs like $300 some. My kids don't even like it anymore. It's not fun there. There's no couches. There's no, it's carpeted floors, right? With you have 3 kids and a carpeted floor. And the other side's always, oh, you didn't bring enough snacks. You can't put my son on timeout, right? So the other lawyer is an officer for the court, and you gotta accept that you don't know anything about them. Maybe they successfully argued an appeal in front of a really important judge 27 years ago. And made their whole career, and they're still practicing. Maybe you don't know that. Maybe the judge at your conference has previously taken kids away from abusive mothers and made them go live with the father at a trial. You don't know that. These are both facts in my case, actually. You don't know unless you look. So you have to be respectful to everybody, including the other lawyer. Just because they're a mouthpiece for your worst enemy. Yeah, they're still human, and the judges are human too. One really thing that's human about the judges is that they are VIPs if they're federal, and they let it get to their head. And they can interrupt you, you cannot interrupt them. If you do, you're derailed, because they will convert all of their energy focused on telling you not to interrupt them. And you're derailed. You're done. They're done listening. You're done talking. Your motions, your hearings, whatever you're doing is finished. Don't ever, 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 ever interrupt a federal judge. Because you're done. They're done. You're done. Uh, it's me. I'm the type of person, I interrupt people all the damn time. A federal judge is not going to tolerate it. So, 35 minutes. I am set for a second settlement conference today. I settled all of her claims in June, all of them. I gave her the restraining order. Family violence, talk about family violence in Ontario, domestics. This is dealt with by the Ontario Court of Justice, unless you're indicted. And then if you're indicted, you may elect to the Superior Court. That's called a defense election. It's up to you. I was indicted. The reason why I was indicted was because I didn't consent to proceed by summary conviction. The reason I didn't consent was because strategically I wanted to put the Crown in a position where they were going to have a jury trial for an assault complaint that was 5 years old. It was my daughter's birthday. Their mom came to pick them up. This was last year, Feb. She met my other girlfriend, my new girlfriend, or whatever. Spazzed right out. Took the kids away, called the cops in the parking lot. None of this has been tried yet, so I don't want to give any details, because if this hasn't been tried, this is all my testimony, but I'm talking about my experiences in court. So what my experience in court was that if you don't consent to the limitation period, let's say something similar happens to you and you're charged for some ancient thing that she brings back up years down the road. Ultimately, the end result is that if you get a discharge, you don't have a conviction, you don't have a permanent criminal record, the police don't care. Family court doesn't care. The other lawyer in family court is going to say you were convicted. And you're going to be like, well, no, I wasn't convicted, I was discharged. Deaf ears. Nobody cares. The cops. Reverse onus statutes. In order for you to be held without bail, not held without bail, sorry, reverse onus means that you need to convince the JP that you should be in the community, not the other way around. The Crown onus means that the Crown needs to convince the JP you need to be locked up. However, police can oppose bail, it's called reverse onus, if you're previously convicted of domestic violence. And they apply that very liberally to basically mean previously charged, previously suspected, previously discharged. That all applies, and they consider it a conviction. In the police's eyes, once you're charged, you're guilty. You're already convicted. They don't even know. They don't care. They don't know or care about these legal technicalities. They bumble and fumble on purpose. They have a huge liberty to do that, and the Crown is obligated. It's in the public interest by statute. The Crown is obligated to proceed. So. If there's any domestic violence claims in your case, they're going to confound it a little bit, but it's going to be handled in the lower court like 99% of the time, like unless you really hurt them, in which case you're bad and you should go to jail. The other 99% of the time is probably mutual violence, it's probably mutual abuse, it's probably neither one of you knew the laws or knew what a scourge on society it is, and it's probably just a lot of egos, and then somebody called the cops, and when the cops assess mutual violence, they have their own set of criteria, but the only thing they're really going to look at is who's bigger, and then your whole life follows that trajectory. So if you're bigger, then you have more responsibility not to fight with the other person. And if let's say the other person likes starting fights and losing and then acting like a victim, guess what? They're a victim. So even if you get discharged or whatever, the cops still think you're convicted. The other lawyer is still going to tell the court that you're a convict. It's all, and that family violence is, and if it's the only thing they have, it's the only thing they're going to talk about. So today, at my settlement conference, I'm looking for a parenting order. The other side has already told me we're not going to settle. So I have my conference bundle here for today. As I said, it's a second settlement conference, which I feel is unusual. It's because we spent the entire time at the first one talking about her issues. I'm the applicant. She has a lawyer. I'm accused of family violence. The procedure is this. We're going to completely coddle the other side. Completely. Until the trial. And then we'll see what evidence you come up with at the trial. So, I've never had a trial in my life. I made my defense election to the Superior Court, and then I had a Crown resolution meeting. We de-escalated to the Ontario Court of Justice, and I got a discharge because the Crown couldn't bring a jury trial to the Superior Court of Justice over some 5-year-old assault charge. I guess we're done with this video here. I'm coming up on 42 minutes. At my settlement conference, the number one document is the offer to settle. You need to include an offer to settle. It needs to be a Rule 18 offer to settle. It needs to be signed by you. It needs to be served. There needs to be an accompanying affidavit of service. It needs to be filed with the court. All of these things trigger a Rule 18 offer, which protects you against cost awards. Parting words about Canadian law. What I've learned in the last few years, the number one word they use is reasonable. It literally is the biggest rule to follow. If at any point in time you're unreasonable, you're wrong. So, food for thought. That's every law in Canada. Like I said, it's like we have like Schrodinger's laws. They're both true and untrue. I'm going to elaborate on this right now. It's called the Oakes test. 1996 Supreme Court of Canada, Arvers Oakes. Reverse onus statutes, constitutionality of reverse onus statutes. This guy had some drugs and I don't remember, they wanted to hold him without bail because he's suspected of trafficking, and I don't know if these are the correct details or not. Anyway, the end result is this. The Supreme Court has decided that Section 1 holds, except that it can also be overridden when such principles are necessary in a free and democratic society. What that means is that we can change any law as long as there's some merit to this concept of it being a free and democratic society. Then your rights have limitations. That's what it means. Your rights have limitations. Our laws have limitations. Laws, in Canada, common law, in the Commonwealth, the law is passed by Parliament, but Parliament doesn't make the law. The judges do. It's called judicial independence. The judges make the law. They decide the facts. They are the trier of the law. And what that means is you can't just rely on what's written, because what's written has to be interpreted always through case law, like the lens of what another judge has already decided. because as far as I know, 99% of the time when the judge decides the law, and when one judge has already decided the law, the next judge is going to agree with them. And the process for reaching the core truth for grinding the untruth side of this process is to escalate it to higher and higher courts and get more and more judges involved until we reach the Supreme Court, and then they lay down the law of the land. So you can't just depend on your own interpretation of written laws, because you're going to be wrong. They've already been applied. The best thing you can do to help yourself here is read cases like yours, or just cases in general. You learn how judges write, how they make their decisions, what things they think about, and if you really do a good job of it, you can accumulate citations that you can look through and try and get to the bottom of what the law actually is, because what the law actually is found in the judge's decisions of cases. Thanks for your time.